My name is Alan Siegel. I'm an attorney, partner in the firm of Levy Sonet Siegel in New York. I am, and have been for the past many years, ASID's National Legal Counsel, and have the privilege of representing many design professionals around the country and even outside of the country. I'm a co-author of A Guide to Business Principles and Practices for Interior Designers. And I speak very often at design events on ASID business practices, designer practices, and the contractual matters, fees and compensation. Aside from representing ASID at the national level, we also have involvement with ASID chapters at the local level. And many of my clients are ASID members, so I get to do both. People have asked me, what do I believe is the most significant phase of a design project? For me, it's simple. It's everything leading up to the signing of the contract. Because projects, in large part, stand or fall on how good you, as a designer, approach this pre-contract phase. The contract serves to educate the client. And in many instances, the contract also serves to educate the designer. Clients come to designers with varying expectations and knowledge of what a designer does. Clients come with some extraordinary expectations. They've heard a lot about designers, reading magazines, newspaper articles, so on and so forth. But the reality is, until your client or prospective client actually has a discussion with you, your client, he or she, doesn't really know what to expect. And this is the one and only opportunity before you enter into a contract to start teaching the client, to help sensitize them to what the project is going to be like, the good, the bad, the ugly. But it's not so much that a contract needs to be available in the event of a dispute. Sure, disputes happen, and a contract document is obviously important evidence, but from a practical, professional point of view, the contract is a tool to help the client become comfortable and to manage your client. Every interior designer must enter into a written agreement with the client. It shouldn't be an optional activity on the part of any practicing designer today. ASID's last issuance of residential contracts was back in 1994, so that's quite a few years ago. The design practice has changed, the clientele has changed, a lot has changed in the industry, so have a lot of the provisions in our agreements. What's interesting about the new residential agreements that ASID is marketing is that, unlike prior agreements, we have adopted a letter agreement format. The older ones look like the standard form agreements that you see that look like legal documents. That works particularly well in non-residential projects. Doesn't work so well in residential projects, either for the client or for the designer. A letter agreement is a contract. It's a legally enforceable document so long as you comply with the requisites of basic contract law. The new ASID portfolio of contracts differs not just in the fact that they're contained within a letter format as opposed to, quote, a formal contract, close quote, format. They contain a lot of new provisions. They contain a lot of optional provisions that might be considered by the designer and the designer's clients. It's a framework from which to build your design agreement. Provisions that were not employed years ago are now starting to be employed in contracts. So we took this opportunity not to just transform ASID agreements to a, quote, friendlier, close quote, looking agreement, but to add a lot more meat and substance from which the designers can pick and choose and modify the agreements. The initial production of ASID documents will have 8 different residential form of agreements. If I were to guess, I would say 85% of each contract is somewhat the same, if not the same. Most of the changes, most of the differences are found within the compensation mechanism. Are you working on a fixed fee? Are you working on a fixed fee for design concept services, a markup on purchasing, and an hourly on project administration? Are you working on any combination of these? Are you working purely hourly? So what we've done is to create 8 residential agreements that contain pretty much all of the same legal and business terms, but for the fee arrangements. And that should be of particular interest and concern for the practitioners. One of the exciting, if I could use the word exciting in the same sense as contracts, is that ASID wants to deliver a product that is very flexible and easy to use. In the past, ASID standard form agreements were printed and sold in packages. Today, ASID is going to, in effect, publish these documents on its website, make it available for download by each designer so that the designers can then, within their own office, easily modify the agreements, print it out on their own letterhead, and it's somewhat akin to your having your office create and print the documents themselves. The key here is that they are versatile. They're versatile in the sense that you are encouraged to make the modifications that you deem are appropriate. It's a very convenient portal to create each and every designer's contracts customized to fit their particular purposes, but at the same time, we try and use our own body of knowledge to have the contracts address the typical concerns and issues that most often come up in design projects. So it's the flexibility of the alternative fee arrangements that vary from contract to contract. But a lot of the boilerplate, the legal protection, you'll find in each of the contracts, as well as some of the optional clauses. It's not ASID's objective simply to turn these documents loose on you. It's ASID's objective is to help you understand these documents, how to use them, and how to best protect your interests and the interests of the profession that you represent. One of my biggest concerns as an attorney in using, for lack of better words, a standard form of agreement or any pre-printed form of agreement is that it leads to a fill-in-the-blank mentality, a kind of legal paint-by-number set. They're not to be used this way. Just the opposite. They're intended to be changed, modified, rearranged, whatever you need to do to make that particular contract applicable to your particular project and your client. So it would be a big mistake to simply take one of these documents out of the drawer, fill in a client's name, put a dollar amount in, and think you've done the right thing. It's only the beginning, okay? So a big con is that you use the agreement in the wrong situation, or perhaps you as the designer don't truly even understand its terms and accept the terms merely because it's pre-printed or it comes from ASID. We don't want you to do that. One of the advantages is that you need not reinvent the wheel every time you need to submit an agreement. It's available to you. You don't have to necessarily spend hours and hours and hours trying to write your own agreement, which I think is bad practice anyway. You're encouraged to talk to your own local attorneys, discuss the nuances of the project, make the modifications consistently so the other terms of the agreement apply. Take, for example, there's a provision in the letter agreements that deal with dispute resolutions. You have two optional provisions. One is the traditional court forum. The other is an arbitration forum. I would certainly expect that those decisions as to which dispute resolution you want to choose should be discussed with your attorney. It's important to understand that having a written agreement does not eliminate all risks. It helps mitigate the risks from the beginning of the process by educating your client all the way through the project completion. But having provisions that potentially limit your liability, having provisions that help mitigate the kinds of exposure, having provisions that help avoid the dispute from occurring in the first instance, it's one of several tools. It's a critically important tool. But I would say this, that not having a written agreement is sure an invitation for a dispute. Let me give you a very basic example of where there could be a misunderstanding absent a written agreement. Let's say a client calls you in and wants to do specific rooms, or at least focus initially on those specific rooms. But the client also shows you other areas of the house and speaks to, well, we would also like to do this particular room down the road, so on and so forth. If you're working on a fixed fee agreement with a client and your agreement, and you don't have a written agreement, what rooms are you responsible for? Was it the 3 rooms that the client said they want to start with, or was it the other 7 rooms in the house? Seems like a pretty basic question. Well, this gave rise to a dispute not too many years ago, and some third party had to decide whether or not the designer's fixed fee for the designer services were limited only to the 3 rooms that the designer assumed were the case, or the 7 rooms that the client thought was covered by the fee. Simple problem, should never have happened. Time and time again, I meet a new client and they say to me, Alan, I know I need an agreement with a client, but I want you to make it just a paragraph. My response is, go out, shake hands with the client, and good luck. Having an agreement that doesn't contain all that it should contain is more dangerous in many instances than having no agreement at all. And quite frankly, the length of an agreement, and here were the ASID letter agreements we're speaking of just a few pages. Usually that concern is the designer's concern, not the client's concerns. Clients very rarely balk at the number of pages contained in an agreement. What they balk at are unfair, unreasonable terms, or it doesn't reflect the business deal. But clients don't walk away from agreements. The design profession in the past has, in many ways, been largely hesitant, thinking that clients won't sign an agreement. Well, if I were a client, I would expect you to be presenting me with a letter of agreement. It establishes your professionalism, and quite frankly, it's the right thing to do. I think each of you will find these agreements helpful, educational. Even if you don't use one of them, read them. It'll throw a lot of light on the practice of interior design and provide you with a great deal of food for thought.